specifically listed your Michigan bar license.
That's correct.
You never told them your Michigan license was suspended.
Correct.
You testified untruthfully under oath.
Yes.
You agree that you submitted a false resume.
Correct.
And then you submitted a false affidavit of personal history.
I really want to know what your relationship to the truth is.
Mr. Wisz, how many times have you been disciplined?
3 times.
In count one of that, you admitted filing a false marriage certificate with the Oakland County Register of Deeds. Could you please explain the circumstances behind that?
It's kind of complex in that I was married prior, and my attorney at the time, who was a friend from law school, she had said that she had entered the proper order of divorce, but she created a false document. I didn't find that out until my first wife tried to get a marriage certificate, and she came to me and said, "We're still married." And I said, "That can't be possible. You know, I gave you the document." She's like, it is. And so when I investigated it, this is what I found out. And because I was kind of at a loss as to what to do, and we had friends that were, one was a pastor of a church. We had them do a new certificate of marriage, and the date I used was the date of the original marriage, which was improper. It was about a year later, I believe, that this marriage certificate was created. It all had to do with the date being our original date of marriage rather than the date that the new marriage certificate was entered.
Do you believe you have a clear understanding of what's expected of you if you are given a chance to practice law again?
Yes, absolutely. I mean, like I was saying, the custody battle, it created such a loss of perspective on me, and the higher standard that I was supposed to meet as an attorney, and I didn't realize it in the sense that I got so caught up in the custody battle.
Why do you believe that you're able to be recommended safely to the public by this board today?
I'm essentially a new person. I really just want to put it behind me and move forward.
So the second count of that first discipline dealt with the taking of a notebook from Ruth Plosky during a break in the deposition. How do you see and explain that today?
Well, there's basically a court order for her to turn over her notebooks, and for her to bring notebooks to the deposition that were not turned over, I thought was just antagonistic, just the point that she was ignoring a court order. And I thought that as an officer of the court at the time, I could take the notebook.
Mr. Dinan asked you specifically if, since your last order of suspension, whether you have held yourself out as an attorney, and you answered no.
Right.
Remember that? Okay.
That was, you're talking about Gentex.
Yes, sure.
Yeah. Oh, that, right. And that's, I agree that I should have been forthcoming, but I was never asked the question and I never volunteered it. And that's where I made the mistake, that I should have just volunteered it at the beginning.
And you submitted a resume that specifically listed your Michigan bar license as correct?
That's correct.
You never told them your Michigan license was suspended.
That's correct. That's what I said.
You also then submitted a petition for reinstatement to the Attorney Grievance Commission and the Attorney Discipline Board, where you lied about your employment history, correct?
Yeah, I mean, I guess.
There was findings as well in that you had worked for a group called Volta Law Group as well, correct?
Yeah, that was kind of like piecemeal work, though. That was not attorney work. That was, like onesie, twosie, and you write a patent on this or that.
You're aware that the panel's findings specifically said you should have reported that and did not.
Yes, that's correct. I should have reported that too.
Do you agree that, in fact, you were the one who obtained the second certificate of marriage, that you brought it to a Bible study class and had the pastor, Miss Plosky, and two parishioners sign it under the guise of clearing up a paperwork issue regarding the first certificate?
Yes.
So she did not take part in a second marriage ceremony because she wasn't even aware it was a marriage ceremony at all, correct?
Well, she signed the document.
She signed it under the guise of clearing up a paperwork issue.
Well, yeah.
Okay. She was never told, at least not at that time, that the first divorce wasn't actually in effect, and that so technically when you married her, you were still married. And so rather than go to her and the pastor and explain the situation and say, here's what happened, you didn't just tell them and then have a second actual marriage ceremony, correct?
That's correct. I wish I would have, because
Okay. So instead, you hid it from your own wife and the pastor, and you actually are the one who wrote the wrong date on it, correct?
yes, yeah, I'm taking responsibility for that. And like I said, because of the religious nature of them, I thought that that was the best way forward.
So you did this without the knowledge of your second wife, Miss Plotsky, getting her to sign it, getting the pastor and 2 parishioners to sign it, and then you later said you had a marriage ceremony, but you did not, correct?
Well, I considered that a marriage ceremony when we were all together. But yeah, otherwise, that's correct as far as the dates.
So the next act of misconduct that I want to talk about was the taking of the notebook. This was your then ex-wife's notebook or soon-to-be ex-wife's notebook.
Correct.
Okay. This took place during your deposition. Is that fair?
Correct.
And there was a break in the deposition.
Correct.
Everybody left the room.
Correct.
You waited till everyone left the room, then went back in the room and retrieved the notebook. And you took this out of your wife's bag or purse, correct?
Yeah, it was like a briefcase.
I believe you called it a journal, but the only thing in the record is that it contained her personal notes regarding strategy and privileged discussions with her attorney, correct?
Right. That's how she characterized it. Correct.
You never returned the notebook, correct?
Correct.
And there's actually a finding that this constituted larceny, a crime, correct?
No, I don't believe there was any finding of along those lines.
In the attorney grievance proceedings, it contains the finding that this was larceny.
If that's the language used, I'm not disputing that. Yeah.
The 180-day suspension was based on a consent order, correct?
Correct.
And you agreed, at least pled no contest to all the allegations of the formal complaint and all of the findings of misconduct, correct?
Correct.
So I understand that a criminal action was not brought. My question really just relates to the finding of larceny in the attorney grievance proceedings.
Yes.
So you testified back in December, and I think you repeated it today, that you believed as an officer of the court, you had the right to take this notebook from your wife's purse or briefcase while nobody was looking, correct?
Well, the court reporter was there, and like I said, there was a court order that she was to turn over.
So the next finding in the order of the 180-day suspension was that you sewed a recording device into your son's clothing.
Correct. Well, it was in his backpack.
Okay. You sewed it into his backpack that he then took into his therapy session.
Correct.
And you listened to this private conversation.
I don't think it was a private conversation. He's a minor.
You know that there was a finding there as well of wiretapping, essentially.
Yes. Yes.
There was also the testimony during the PPO matter where you provided false testimony, correct?
Correct.
I think you described it as not technically correct, but it was false testimony, right?
Well, in the sense that if that was in the consent order, then I agree. But I was again trying to convey that it was what the circumstances were about that.
So you testified untruthfully under oath when asked whether your son was ever exposed to a girlfriend. Is that fair?
Yes.
you agree that you submitted a false resume, correct?
Correct.
And then you submitted a false affidavit of personal history to the Attorney Grievance Commission.
Yeah.
You admitted some pretty poor decision-making. Is that fair to say? And so, our concern not only is the past behavior, but is the future prospect for better decision-making or continued poor decision-making. And so what I really want to know is, tell me what specifically right now, as we sit here, what have you done to prevent this poor decision-making in the future?
Well, I sorted out my employment. I'm very happy. I have a 5-year-old who I drive to school every day. I will be coaching his baseball team. I volunteer at his school. Essentially have a whole new life. And like I said earlier, I don't know if it sounds bad. I kind of had to wall myself off.
My question again is, what have you done? What have you done personally to prevent this poor decision-making? So, for instance, wife number 3 leaves you and there's a new custody battle. That is not outside the realm of possibility in Michigan or any other place. What have you done as we're sitting here to prevent the kinds of behaviors that cause you to be sitting here?
First off, my current wife is not crazy religious. And secondly, I've reflected a lot. I mean, I've thought about this a lot. I've lived a lot.
Well, let me stop you there. What have you learned?
I've learned that I have to be held to a higher standard and I have to be responsible for my actions. I've made a lot of bad decisions in the past. I grant you that. But you can see that they're all quite a few years ago, and they were right in the heat of that, where I was caught up with things. And now,
okay, let me stop you. So just looking at it, and I'm not trying to be super hard on you, but I think in a way, I really want to know I need to know what your relationship to the truth is. And so how are we able to go forward? What's your statement about that? How are you going to do something different?
I didn't think there would be such consequences associated with the divorce in my professional life. And people would tell me who got divorced that it's like, oh, it's a game. You have to play the game. And I got caught up in that.
Have you done any kind of ethical, continuing legal education on ethics, anything like that?
To be a volunteer in your school, I had to take different classes.
Right, but I'm talking specifically here about legal ethics.
Legal ethics, no.
My client indicated clearly that he was the author of his own disaster. And he has learned, albeit the hard way, that when he tries to do things his own way, when he tries to shortcut things, that it ends up being a disaster for him. And he's done that 3 times. I believe that he has learned his lessons from that, and he can be taken, safely recommended to the public as a counselor, but he ultimately knows that he owes a duty, first and foremost, to conduct himself in a manner that's proper. So please give him an opportunity to return to practice.
Ms. Lindsay?
So the Michigan Supreme Court said in Grievance Administrator versus August that to grant a license to practice in Michigan, the panel affixes its stamp of approval on the petitioner. To do so for someone who has committed serious misconduct requires a searching inquiry into the causes of the misconduct and the most convincing showing that a genuine transformation has occurred. Mr. Wisz has not complied with the terms of the order of suspension. He held himself out as an attorney while he was suspended. His conduct since the order of discipline has not been exemplary and above reproach. The 2 major issues here are his dishonesty and his disobeyance of court orders, taking into account all of his conduct, which includes before, during, and after. Can he be safely recommended as a person fit to be consulted by others to represent them in matters of trust and confidence. And the nature of the misconduct is really dishonesty. There are multiple acts of dishonesty that Mr. Wisz has engaged in rather than just admit that a mistake had happened. And it wasn't even his mistake. It was a divorce attorney who gave him a false certificate of divorce. But rather than admit to his then, who he believed to be his wife, that a mistake had happened and just get remarried, he presented a new certificate, and under the guise of cleaning up an error, he had everyone sign it and he filed it. He finally admitted today there was no marriage ceremony. Everybody signing a new certificate under the guise of cleaning up errors is not a marriage ceremony. Then in 2016, he stole a notebook from his wife's purse. He believes even today that as an officer of the court, that he could engage in self-help and steal a notebook that he believed he was entitled to. He continued to justify sewing a recording device into his son's backpack and eavesdropping, which means there's no assurance that he will not do the same thing in a similar situation because he believes he is entitled to. The ends in his mind justify the means. There were findings that he repeatedly and knowingly disobeyed court orders. And this was not just about parenting time. This is about a variety of issues, and that has not been addressed. In 2016, he also testified falsely as perjury. And in 2022, the judge made findings that he testified untruthfully repeatedly in the parenting time dispute that was going on. So much so that she said she could not believe anything that he said. Then we have the circuit court findings, and the judge found that Mr. Wisz provides falsehoods with ease and without remorse. He is without credibility, and the court finally said that the court could not trust any representation he makes. What we see is time and time again, when given an opportunity, Mr. Wisz chooses the easy path. So he has not met his burden because he hasn't shown that he's learned his lesson. He hasn't shown that his conduct will be different, and he hasn't shown a genuine transformation. He's just said that the stress has been removed. Thank you.
Thank you, counsel, for both your work on this. What we would like is for proposed findings of fact and conclusions of law or statement of law. We don't want it long, like 5 to 6 pages at the most. That we would like that done within 21 days of today. Once that's done, the panel will meet and we will discuss those things, and we will then issue a decision.